This is Greg Tripoli from the Onondaga Historical Association. This is the second interview with Judge Hancock here at his office in Cazenovia. The date today is June 13th, 2012, and second part of Judge Stewart Hancock's oral history interview. Judge, we've spoken a little bit about this, and the practice of law isn't always work. I know that you're someone who also likes to have a good time and a laugh every once in a while. So I'd like you to tell us some about the lighter moments that you've enjoyed over the years in practice and on the bench.
Well, being on the appellate division was in many ways the most fun of all my judicial experiences. I think when I was on the court, we had a very collegial court. Everybody was very friendly, and you felt free to joke and kid, and nobody took offense. And so one of the high points of being on the appellate division would be when a particular judge dissented in a case alone. And that was a risky thing to do. And then the case would be appealed to the Court of Appeals. And of course that dissenting judge would be watching very carefully to see when the case might be decided. And so when the judge did see that the case had come down, and in the rare event that the Court of Appeals had reversed the case, not writing a new opinion or decision, but doing so on the basis of the dissent at the appellate division by this particular judge, then in those rare moments the victorious judge would come into the meeting of all of the court sitting around and pretend to be looking over the agenda for the meeting and so on, and hoping that somebody would bring it up, and somebody would say, "Oh, did you see that case came down from the Court of Appeals?" And then the dissenting judge, who knew all about it, of course, would, "Oh, really? Well, tell me about it. I didn't see it." And then they would have to say, "Well, it was a reversal." And then the dissenting judge would say, "Well, that's interesting. Did they write an opinion?" "No." "Well, what? How did they? How did they reverse it?" "Why, they did it on your dissenting opinion." And if it got that far before they threw the judge out, that was always a miracle, because by that time, of course, they knew that the judge was kidding, knew all about it, couldn't wait to have somebody bring it up. And so you could do that sort of joking and kidding and so on in the appellate division. Couldn't do that at the Court of Appeals, which was much more serious and more educational, more challenging for me, but not as much fun, I must say.
You've worked on some cases that have been particularly interesting. One that we talked about a little bit was the America's Cup case, and I'd like you to talk a little bit about that.
Well, this was lots of fun for me. The way this came about was that the Mercury Bay Yacht Club in New Zealand had issued a challenge to the San Diego Yacht Club, which was the winner of the cup in the preceding series. So they held the cup, and so they were the defender. And so Mercury Bay had issued a challenge and given the description of the sailboat in which it was going to make the challenge. And it was an enormous monohull but within the limits of the deed of gift, which had been given by Mr. Schuyler back around 1885 or 1890, something like that, the deed of gift to the New York Yacht Club. And so the challenge was legal, but it was just within the limits, and it was contrary to what had always been assumed to be the unwritten rule that the races were supposed to be in 12-meter yachts. So New Zealand really broke the rule and issued a challenge with this very large monohull. This was challenged and went to court, but it was held that the New Zealand yacht in which was going to make the challenge was legal. So this annoyed, enraged, perhaps, the San Diego Yacht Club. So they said to themselves, well, all right, they want to play that way. We'll play that way too. So they decided to challenge this monstrous monohull with a catamaran, which I must say, in the year 1880, no one had ever heard of. There might have been some catamarans then, but no one had ever heard of racing in a catamaran. And so then San Diego turned around and said, oh, no, you can't possibly meet our challenge with a catamaran. That's not within the deed of gift. And so that went to the lower court, who happened to be a judge, Judge Saperic, who now was on the Court of Appeals, and she held, looking at the deed of gift, indeed, that it was not permitted within the deed of gift, because the only mention of any relevance to the limits of the contender in the deed of gift was the length on the load water line. And of course that has nothing whatsoever to do with the catamaran. It's a measure of hull speed for a monohull, but irrelevant as far as the catamaran is concerned. So she concluded, and I think very properly, that it wasn't allowed. So then it went to the Appellate Division. It was reversed. They said, yes, it is okay. And then it came to the Court of Appeals. And so we had the argument in the Court of Appeals. 5 of the judges decided that it was okay to meet the challenge in the catamaran, but I dissented, and I don't know whether I might have told you this the last time, but Vito Titone, who was on the court, came to me and he said, well, you know, I don't really understand all of this business about hull speed and monohulls and length and so on. And I said, Vito, don't pay any attention to that, just agree with me. So he said, okay. So he agreed with me. It was 5-2. And so that's the way it was. And there's absolutely no question that it, in my opinion today, that it was not a proper challenge. And I guess I might have told you the last time that when they had the race took place before it came to the Court of Appeals. And when they had the race, the press were following, and press boats and so on. And the catamaran, when it gets one hull out of the water, you know, can go with a good breeze. This could go up to 20 knots, 15 to 20 knots, and the maximum hull speed for this monohull would have been probably 7 or 8 knots. So the newspaper people following would see the catamaran getting so far ahead that it would luff up into the wind to bring the windward haul down, to slow down, to let the old lumbering monohull catch up a little bit, to make it look a little better. And anyway, so that was fun, and of course I got a lot of comment about that.
Judge, you spend a lot of your time now, as we know, on pro bono work.
Yes, I do.
And in the first part of the interview, we talked about a case that was particularly close to you in the sense that you were working on it at the time, or just completed it, and you felt very strongly as you're passionate about your work. And so, since there's been a bit of time that's elapsed now, I asked you if you had heard anything new about the Current Cross case, and so if you could bring us up to date on that a little bit, and talk
Yes.
about your pro bono work.
Yes, at the last time that we talked, the motion that I had made in county court, a criminal procedure law 440.10 motion, based on the fact that the defense counsel at the trial level had not made the proper objections, so that the main issue in the case, which is whether or not there was sufficient proof of the main crime, that's aggravated criminally negligent homicide, whether there was sufficient evidence of that, so that that issue could be talked about and argued about on appeal. And the courts had held no. The trial lawyer, Mr. Piemonte, had not made a sufficiently precise objection for the lack of evidence of this main crime, so that it was not preserved for appeal. So here you had the case in the appellate division and later in the Court of Appeals, but you couldn't argue the main point. And so we claimed that it was preserved. We tried to claim that, but that argument was shot down. So there we are, without up the creek without a paddle, so to speak. And so the basis of the 440.10 motion was that the defendant, Josh Carncross, had been deprived of his ineffective assistance of counsel because of the failure to preserve this main issue at the trial level. That case, that proceeding came on at county court, and we received a decision a couple of weeks ago denying our motion for 440.10 relief. So now I am bringing a motion directly in the appellate division for a writ of coram nobis. That's C-O-R-A-M nobis, N-O-B-I-S. And the basis of that application is that the appellate lawyers, meaning me, among others, and I will take responsibility for having made the critical decisions, we did not make an alternative argument at the lower level, which would have said, all right, we think it was preserved properly. We don't think the cases that they're citing, which claim that there was no preservation, are proper or relevant. But if it turns out that that's not so, then we bring an alternative argument to the effect that the trial lawyer at the trial level was ineffective, was negligent, and so on, in not doing it properly. we didn't make that alternative argument. So there's a basis for issuing a writ of coram nobis because really it would amount to both ineffective assistance of counsel by the trial lawyer, but also ineffective assistance of counsel by the appellate lawyers, including myself, for not making this alternative argument just in case it should be held, contrary to what we thought was the case, that the trial lawyer had been ineffective in not making the proper motion. So that's what we're doing now, and so this writ for coram nobis application is made directly in the appellate division. I'm in the process now of drafting papers on that. So there we are on that. And let's see. I might have mentioned the Ingram case the last time. That was one from Hiscock Legal Aid, and that's a case which I argued in the Court of Appeals, and that has to do with the use of this new statute which makes it illegal for somebody who's in custody or being questioned to not tell the truth to the police. And so anyway, I won't go into the details on that, but I did get a reversal in the Court of Appeals, and so it was sent back to county court for further proceedings, and the lawyers who represented Mr. Ingram and the district attorney reached sort of a settlement agreement to lessen his prison sentence, or to let Mr. Ingram plead down to a lower, a less serious offense. And so they have arrived at an agreeable solution to the thing. So I am pleased about that, because the work that we did in the Court of Appeals did produce something which was of some benefit to him.
Judge, we talked a little bit about the mentors that you have had in your life, and you spoke about some Supreme Court U.S. Supreme Court justices that were influenced you professionally, but on a more personal level, the mentors and teachers that you've had. You mentioned the late Justice Robert Whitmer.
Yes.
As one who had a particularly strong influence.
Yes. He was a senior member, perhaps the senior member of the Appellate Division when I was appointed to that court. And he and I just seemed to hit it off. He took a great interest in me, and I admired him very much because he was meticulous about his writing and meticulous about his analysis of a case. And so he worked with me, I think, criticized some of my writing and improved my writing. And he and I often agreed and sometimes dissented together on cases where we thought that the analysis of the other side had been wrong. So, yeah, he was a truly dedicated, remarkable, professional judge, in my opinion. And so I think he taught me a lot. I think he inspired me to be more careful, more meticulous, and I think that he improved my writing. So yes, he was a mentor, and we became great friends. And I'll never forget going to, I believe it was his 101st, I might have mentioned it the last time, 101st birthday party. And it was at a very fine retirement home up in Rochester. Lots of people were there, and I was just so impressed with him. He met everybody, remembered everybody's name, stood absolutely straight, good posture, looked everybody in the eye, and all the time he was holding a straight-up martini. I found out later from one of his sons, might have been Bob or one of his other, I think he had another son, that they were careful to water the martini before they let his 101-year-old father stand there and hold it. But he was remarkable.
You've written that Chief Judge Judith Kay
Yes.
was a judicial colleague of yours who helped to make you a better judge. And you can talk about how she helped you make a better judge, and then if you could segue into how the role of women in law has changed over the years since you were admitted. And so, first Judge Kay.
Well, Judge Kay, Judith and I became very good friends. When I went on the Court of Appeals, I had not known her before, and we've been very, very good friends, close friends ever since. In a way, she impressed me and taught me in the same way, perhaps, that Robert Whitmer did. She was very meticulous, very, very careful, and so she taught me a lot about that. Also, I think that she sort of welcomed me in to the Court of Appeals. She was not Chief Judge at that time. She had been appointed to the Court of Appeals in the previous opening, the previous appointment to the court. So she was relatively new on the court when I went on, and so she sort of eased me into the ways of the Court of Appeals and differences, what you do, what you don't do, what's a no-no, all of those sorts of things, which were somewhat different from the much more flexible, loose, easygoing ways of the appellate division. And in a way, not as much fun, because you didn't really have the sense of humor and all of that I sort of missed that from the appellate division. So she welcomed me, she helped me, and not only professionally as far as the work is concerned, but in sort of welcoming me into the court and showing me how things worked and all of that sort of thing. So, yeah, and she became great. She and I became very good friends, and still are.
And the role of women in court, how has that changed over the many years? No
question. There's been a tremendous change, and I think it's for the best. Well, when I left the court, at one time there were 4 women after I left the court. Judith Kay was the chief judge. There were Judith Kay, Saparic, and the 2 other judges on the court, 2 women judges on the court. So that's 4 of the 7. And before, I think that Judith Kay was the first woman to be put on the court. So within the space of 10 years, 15 years, there'd been this enormous change on the court. And of course you see that on the Supreme Court of the United States also, with the number of women. You see it here at the Supreme Court level. So there's no question that women in the judiciary have really progressed the number of women. There's no question about that. Now, as far as the practice of law goes, I think I remember my father saying that he hired the first woman ever to be hired in a law firm in Syracuse, and that was considered a rarity. And of course that would have been just one woman, and that might have been, oh good heavens, 70, 80 years ago. And now I don't know how many women lawyers there are in Hancock and Estabrook, but the managing partner of Hancock and Estabrook is a woman, and my daughter, Marion Hancock Fish, is in the firm and a well-known lawyer, respected lawyer in trusts and estates. And I don't know, I would say at least, certainly almost half, perhaps certainly more than a third, and perhaps more than as much as a half of the lawyers in Hancock and Estabrook are women. I'm sure that's quite true in the other firms in Syracuse. And so, I mean, good heavens, it's been such progress as far as women goes. I mean, you take a look at Hillary Clinton, who has done, in my opinion, an incredibly good job as a Secretary of State. And so I think we've reached the point where you don't ask a question at all. You just assume that the woman in the position is just as good as any man in the position. You expect them to do just as well, and they do. I don't know. It's no longer a big deal as far as I'm concerned. And I think this is true of many people, anyway.
But you've watched that evolve.
Oh, yes, it's evolved during my lifetime, during my career. This has evolved. So now we don't think of it. At least, don't you agree with me on that? It's just assumed.
I do, absolutely.
It's just, I mean, so what? They do just as well. What's the big deal? It's sort of the way I think most people look at it now.
I mentioned to you earlier that your name is very well known in Syracuse. The name Hancock. You come from a long history of Hancocks who have made wonderful contributions to our local community. And I asked you about being conscious of that as you were growing up. So if you could speak a little bit to that.
Yeah, you know, really, I wasn't conscious of that. I mean, as I was brought up, I knew, yeah, of course, I knew that my father was a very successful, respected lawyer, leader in the community. I knew that mother was very involved in the community chest and the visiting nurse and the art museum, all of that sort of thing. But I never appreciated that was unusual or that there was anything particularly notable about that. That really nobody ever brought that fact home to me. And I think it's true of the other members of my family. I don't think we we thought about that being unusual, but I think what was always sort of assumed in our family is that you were expected, just automatically expected, to do your very best in whatever you were undertaking. You were expected to do well. Nobody ever lectured anybody about that, but it was just sort of assumed. So I don't know what made that sort of inherent assumption part of my upbringing, but it was there, and it just sort of whatever you were going to do, it was expected you were going to do well at it, or at least do your very best to do well.
Your father, as you mentioned, was a very respected and successful attorney here, and he was involved in a very famous case locally with Teddy Roosevelt, and I was wondering if you could talk about that for a minute.
Oh, yes. I wish I'd had time to read the article that I wrote on it to get the details back, but this was a case which was tried in Supreme Court, Onondaga County, I believe I know it was in 1912, and so President Roosevelt had tried to get reelected in 1908, and didn't get the nomination. Tried to get the nomination, and in 1908, having failed, then he launched his Bull Moose campaign, and Taft was the Republican nominee, and as a result of his launching this third party, he succeeded in getting Woodrow Wilson, a Democrat, elected President of the United States. So during that period of time, somewhere along, he had made some statements about Mr. Barnes, who was the Republican chairman of, I believe he was the Republican chairman of the state of New York, William Barnes, and Teddy Roosevelt, during the heat of this campaign, had made some statements that he was a corrupt boss, or a politician which could be bought, or something like that. And so, after everything was over, then William Barnes sued Theodore Roosevelt for libel, and the suit happened to be transferred from Albany, where it was started, to Supreme Court, Onondaga County. And so that's how my father happened to get into it. Theodore Roosevelt was represented by a very well-known lawyer in New York City, whose name I can't really give you. It'll come back to me later, I'm sure. But anyway, this well-known lawyer in New York City retained my father as local counsel. And so the case was tried in Part 1 of Onondaga County, and if you go into Part 1 Supreme Court in our courthouse, you'll find a chair which has the name Theodore Roosevelt and the date and so on, and that's the chair in which he testified. And so the case came on, there were all sorts of famous witnesses in the case. I wish I'd had a chance to go over my article to fill in some of them. But, well, for example, Franklin D. Roosevelt was a witness. And the famous famous guys. Oh, there was so many. I wish I'd had a chance to go over this a little bit. And so they all testified, and Barnes testified, of course. And then Theodore Roosevelt took the stand in his own defense. And so this was sort of the high point of the whole thing. I remember being told that you had to get reserved seats in order to go and take a seat in the courtroom, and there were seats along the side and so on and so forth. And the judge was a classmate of Theodore Roosevelt at Harvard. And as a matter of fact, the judge was Bill Andrews, whom you probably know, his great-grandfather, I think, or maybe his grandfather, Judge Andrews, who later went to the Court of Appeals. And so there would be an objection by the lawyer on the other side. Oh, I wish I had a chance to go over this, who was a well-known cross-examiner, and he wore sort of a skull cap. Oh, what was his name? Oh, and so he would ask a question of Theodore Roosevelt, and Theodore Roosevelt would then just make a speech, and the lawyer on the other side would try to interrupt and object to his not answering the question, and so on and so forth. And Judge Andrews would agree with the objection and admonish Theodore Roosevelt to, you must answer the question. And Theodore Roosevelt would say, yes, I know. And then he'd just go on and continue with making his speech. He was totally uncontrollable, put on a tremendous show, and eventually, as you probably know, the outcome was, yes, there was technically a libel of some kind, but the damages were brought in were a total of 6 cents. So it's a great victory for Theodore Roosevelt. That's the name. I can't remember the name of that lawyer on the other side. I wish I'd had a chance to review that.
That's all right. I'm sure that'll come to you. I wanted to ask you finally about Ruth Hancock. You've been married to Ruthie for more than 50 years.
62 years.
62 years. Good for you. It's been said often that behind every successful man is a strong woman. And I'd like you to tell us about Ruth, and especially the role that she played in your career, her assistance in your professional life.
Well, she has been absolutely remarkable. I mean, she has done so much to help me and the children, and in so many different ways. She is just a remarkable, remarkable lady. And we were married in my second year at law school, and matter of fact, I've just mentioned this to her. When I first went to law school, my first year and a half or so, I really wasn't working at it as hard as I should have, and so on. And got married halfway through my second year, And I give Ruthie a lot of credit for sort of straightening me out, shall we say. And so I wound up standing very well in my graduating class. I was graduated sixth in the class, which was about 100 or a little bit over 100, and I got to be the second highest, won the award for being the second highest mark on the comprehensive examinations, which is given on the whole course after the person completes just prior to examination. And so then I was on the Court of Law Quarterly, so I give her a lot of credit for getting me going. And then she had just, she's carried on a tremendously important role in the community herself. She's an inspiration, being involved in all sorts of activities, as you probably are well aware. And she's been very, very dedicated to the Pass and Seymour Company and the Syracuse China Company and all of that. She's just a remarkable, remarkable lady, and still is, doing all sorts of things in the community. And one thing that she has so many people who call her to ask for her advice or call her to talk with her. She's a very sympathetic, warm friend for anybody to have. And I don't know, she gets some of the phone calls go on because she's a very patient listener. That may be why she gets these calls. But she's just been, and she has done so much for me, and we love each other very, very much, and particularly in recent years when my eyesight has begun to fail, which it is doing, she has come to the fore and does a lot of driving, which I used to do, and we're at the point where I'm going to have to get some kind of a driver to drive me around. Fortunately, this office where we are right now is within walking distance of where we live, so it isn't such a problem, but it does make it more difficult for me to get into Syracuse whenever I want to go. So, yeah, she has been and still is just an admirable, wonderful, lovable lady who has helped me so much.
Judge, thank you so much for your time and for talking with us during this interview. We appreciate it very much.
Yep. It's been a pleasure. You're a very good interrogator.
Thank you.
Thank you.